welcome General Garland. I feel it's a difficult position for me to question you because I have such respect for your acumen, your probity, and your rectitude, which is widely recognized, but there are questions I must ask. The Senate Judiciary Committee had a report recently about the attempts of President Trump to get Department of Justice employees involved in the Stop the Steal campaign, trying to subvert the election. Are any of those people that were involved in that still at the Justice Department?
You know, all the bold-faced names that I know about were political appointees, all of whom are not at the department. I don't know the answer otherwise, but I don't believe so. But
thank you. I would appreciate if you'd check into that. If they were and they participated in this in any way, that they should come to your attention and they should have certain sanctions, I believe. You have defended and sought to continue to defend President Trump in his defamation action brought by E. Jean Carroll. He called her a liar. He accused her of conspiring with the Democratic Party in her allegation of rape. And for what it was worth, he said she wasn't his type. His type is apparently fairly expansive. And you're defending him. Do you think that the public sees that as a proper use of Department of Justice resources when it's been shown that we're short on personnel in the Civil Rights Division and that we need that personnel, and yet we're defending President Trump's defamation lawsuit by a woman who he has defamed?
Congressman, we are not defending the defamation made by the former president. As I've said publicly several times, sometimes being the Attorney General and sometimes being the judge means taking positions with respect to the law that are required by the law, but which you would not take as a private citizen. In this circumstance, the Justice Department's briefing is not about whether this was defamation or wasn't defamation. It was solely on the question on the application of the Tort Claims Act. And there is consistent precedent in the D.C. Circuit which holds that even defamatory statements made during press conferences by public officials are within the scope of employment for that very narrow purpose and for that very narrow definition.
If I may, sir, and I appreciate that and I've read that, but this was an action he took as a private citizen. He is now again a private citizen and was totally outside of anything to do with him being president. I hope you will look into it again because I think the public sees it as a mistake. The rule of law, you made clear, and I know you believe this, is one of the major tenets of the Department of Justice to uphold the rule of law. Michael Cohen has a felony on his record, spent time in prison for paying at the direction of President Trump hush money to Stormy Daniels and another woman. I believe that it's pretty well known that President Trump was individual one, as described in the indictment. He couldn't be indicted because of Department of Justice policy. You don't indict a sitting president. He's no longer a sitting president. Do you believe that not looking into indicting individual one, equally, if not more guilty than Michael Cohen, is not an abuse of equal protection under the law and an abrogation of the idea that the rule of law is principle?
So, Congressman, and a very important element of the rule of law is the norm of the Justice Department that we don't comment on whether we're investigating, what the status of investigations are unless and until there's a public charge. That's important to protect everyone, whether it be a former president, an existing president, or a public official or a private individual.
I will accept that, but I hope that you will look at it because I believe that he is equally, if not more guilty, and it does seem that people get favored treatment if he's not prosecuted. Transparency is important as well. Amy Berman Jackson tried to release some records concerning Bill Barr's downplaying of the Trump's obstruction of the Mueller investigation. This committee was looking into the emoluments clause violations of the Trump Hotel and got an order to see some records, and yet the DOJ appealed. Do you believe that transparency, those two situations are ones where transparency was not permitted to the American public, as well as the whole Mueller report, which hasn't been redacted?
Well, with respect to Judge Jackson's ruling, I respect Judge Jackson. She was a former colleague. I respect her very much. We just have a difference of opinion with respect to the Freedom of Information Act deliberative privilege exception. And we believe that in that circumstance, The memorandum, which was given to Attorney General Barr, is protected by that so that all attorneys general can receive honest advice from their subordinates. That matter is before the D.C. Circuit now. Everything I've just said is in our papers, so I'm not saying anything outside the record, and it will be resolved by the D.C. Circuit.
Thank you.
Gentleman's time is
I yield back the
expired.
balance of my
Mr.
time, but I
Johnson of
thank you.
Louisiana.